Theme for the first session is Roadmap for Mandatory E-Filing. I now request Learned Registrar, High Court of Sikkim, Ms. Jyoti Kharka Ma'am, to kindly present the traditional Sikkimese Khada to the Chair, Honorable Mr. Justice J.K. Maheshwari, Judge, Supreme Court of India. To the co-chair, Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India. To the co-chair, Honorable Mr. Justice S.V. Bhati, Judge, Supreme Court of India. I now request Learned Member Secretary, Sikkim State Legal Services Authority, Mrs. Shamita Sharma Ma'am, to kindly present the traditional Sikkimese Khada to the distinguished panelists. Honorable Mrs. Justice Anita Sumant, Judge, High Court of Madras. Honorable Mr. Justice Soumitra Dayal Singh, Judge, High Court of Allahabad. Honorable Mr. Justice Mohammad Niaz, Judge, High Court of Kerala. I request Learned District Judge, Special Division 2, Gantok, Mrs. Jwala D. Thapa Ma'am, to kindly present the traditional Sikkimese Khada to the distinguished moderator, Honorable Justice Mr. Suraj Govindraj, Judge, Karnataka High Court. I now humbly request Lordship to open the session as the moderator.
Good afternoon, everybody. We'll first start with the chair addressing the session.
Good afternoon, Brother Justice Sandeep Mehta, Brother Justice Bhatti, Sister Anita, Mohammad Niaz, Brother Soumitra Dayal, Govind Raju, and our technical team. If we look into the session and theme, then we find that what we are doing at present is only preparing a roadmap for mandatory filing. The word important is mandatory filing. I feel the organizers would have introduced this having some intention in their mind. At present, we go, filing is there, then same time, paper filing is also there. I thought the thought process may be until when we thought about e-court functioning and it should be paperless, then the first starting melting point would be that of mandatory e-filing. When there is no paper, it's only a e-filing, and after e-filing, e-scrutiny, then thereafter e-corrections, and everything is e, then there may not be any need for anything others. So this topic, I think, word mandatorily having significance of it. So once we go off it, and we thought, as I already said in an inaugural session, we have come from filing now to the e-courts working. So the thinking today is mandatory e-filing, how we should prepare a roadmap of it. For this purpose, as I think I give to this mic to Brother Justice Bhatti, who will have his own views on the subject. First, he will apprise you, then we'll proceed further. I request Brother Justice Bhatti to take up the mic and apprise all of us.
Distinguished guests, good afternoon. My elder brother, Justice Maheshwari, to make all of you become more alert from the relaxation we had during the sumptuous lunch session, has said, I am going to elaborate on the e-filing system. My journey with the e-filing system, etc., dates back to 2019 20, 20, 21, 22, 23, till I was in Kerala High Court. After coming to Supreme Court, I have forgotten what is e-filing. Since this is a closed gathering, and I should also instill little bit of alertness in the distinguished guests present in the hall, I must say I am here because Chief Justice Mushtaq called me. Chief Justice Mushtaq called me because he knows me when I was in Kerala. Not that I am an expert in this subject. Let me begin from that stage. Dear all, our all endeavors is to make the system more efficient, functional, and also achieve the object for which the efforts are joined together. For a while, I will keep myself away from the role of a Supreme Court judge, for that matter, Chief Justice of Kerala High Court, or a judge of that court and other courts also. I will keep myself as a person having ringside view of the circus or tamasha that would be going on in the courts. No one is interested to come to a court. No, sometimes respondents and defendants alone are invited to courts. But many a time, circumstances push them into litigation. I broadly categorize the understanding of litigation in this fashion. First, it is cause of action or a crime. These two situations will take a person to the counsel for his advice, guidance, and professional services. The professional does his bit. He brings the cause or the crime before the court. We have completed now 4 C's. These 4 C's have been in existence for quite some time. People continue to repose confidence in these 4 C's and the system is running. Now, what is the greatest effort we are making through, you call it e-filing, digitization, digitalization? This is beginning with again computer C. My expectation from this last C is to enhance the functional utility of rest of the 2 C's and give the best of the results for the first 2 C's. That is cause of action and the crime. Whenever we introduce these measures, my expectation is that there should be periodical audit on the performance and the result we derive from the procedures we put in place. When this being one of the suggestions I would like to give on this occasion, another suggestion I would like to leave for deliberation in this technical session is that there is no homogeneous approach in the country. What I suggest as co-chair in this session is, please mark the best of the practices that could be resolved, that could be informed to the Supreme Court committee, take their approval, and after it is tested and processed, the same is universally used in this country. Then the next challenge is how to make these measures user-friendly. Someone has asked me a question. That question I ask myself. Supreme Court, there is digitalization, everything. Still, I keep with me only the paper book. When I am discharging my duty with the help of a specially petition paper book, it does not mean I am against most of the innovative procedures that are being put in place in the system. My answer to such people is, this is not an overnight revolution. It is nothing but a transformative evolution to strengthen the 4 C's I said. I request my other co-panelists to throw light on these aspects, which would finally enable the Sikkim High Court to prepare a draft document and send it to the Supreme Court for further distribution all over the country. I thank my brother Justice Mustak, the High Court of Sikkim, and the government for giving me this opportunity. Thank you. Thank you very much.
Taking back, you have heard Mr. Bhatti. He has given 4 C's: caution, 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 caution. So he has not cautioned all of you, not I am. Remember one thing. And the next part is, it is the best, at least otherwise you will be bored. You will start doing something, pouring something in your mind, you know everything well. And the next part, he gave thanks to Mustaq. Nobody else. And you are cautioned. Anyway, it's not an issue. Issue is what and what manner we have to prepare a roadmap for mandatory filing. I request Brother Justice Mehta, who is having much indulgence on the subject, and he will discuss and he will apprise everything to all of us. Please.
Thank you, Brother Justice Maheshwari Saab, Brother Justice Bhatti. So I don't reserve my thanks to Justice Mushtaq at the end of the presentation. I will give the thanks right away. He knows very well that I am a total novice at this e-filing business. I've never had the occasion to be a part of the e-committee either in the High Court. So only little bit of touch I had when I got to discuss some things with Justice Suman Sham while I was in Guwahati. But still, sincere thanks to Brother Justice Mushtaq for giving us this opportunity. What a glorious weather Sikkim has. Out of the sweltering heat in Delhi, you are in blissful weather. So and of course, AQI of 53. Yes, AQI 53. So when I was thinking that I being a total novice at the topic, and I'll have to share the dais with such diggaj as Justice Maheshwari, Justice Bhatti, what should I say? So almost all of us are a part of this Indian High Court judges group. While we are discussing this roadmap, my feeling is that the biggest stakeholder is the lawyer. Are we asking him what is the impact of this mandatory filing on the way the lawyers used to make the presentations earlier and now they are doing it? So there was a very interesting, there's a very interesting blog by a lawyer who goes under the pseudonym that is Gobbledygook. I'll just read it out, and I shared it with the young lawyer, and his response is very interesting. That perhaps gives us many answers. I'll just read out, it'll take 2 minutes. So he starts with referring to one Honorable Chief Justice of India who introduced this e-filing business. Of course, it helped us, everyone, each court greatly in the COVID times. He says, the illogic in this direction of e-filing was simple. Why burden courts with mountains of paper when you can burden lawyers with mountains of expenses? It was the classic Mumbai Netas go to Shanghai movement. See spotless streets there, come back here and declare, from tomorrow, Mumbai will also be Shanghai. Except here, instead of clean streets, we got clean hard drives. Of course, the 1%, the elite class were thrilled. They already had the iPad styluses and probably assistants named Siri. The rest of the legal fraternity were mere mortals who still believed that the best way to turn a page was with a strategic lip on the fingertip. And then came the notifications. All pleadings must be filed online. Then the advocates on record struggled with the scanning. The cost of scanning jumped. But before they could move on, there was another direction, bookmarking. Well, the lawyers were, of course, in a state of disbelief. What is a bookmark? Bookmark is something we were used to put in the books when we went to sleep. Anyhow, they started looking at the softwares. The softwares are very expensive, the licenses. Then, as our Indian mentality is, we try to crack the software code, go for the pirated versions. But now comes the serious observation. All this had been done, and then comes the direction, please also file hard copies. Now, with that direction, I would like to ask myself a question. Are we really going into paperless courts, or courts which really don't see the paper, but the paper gets on piled in the registry to be scrapped later? The idea, the basic idea behind this development was, of course, to make the filing simpler, easier, accessible to all. But if we are still going to rely on paper, and my next observation will be, yes, we have to rely on paper. And I'll also give the reasoning behind that. But I shared it with a young lawyer, and his answer is interesting take, but overall, the benefits far outweigh the initial difficulties. Bookmarking is available for free on most softwares, and paid versions are not required. These get recognized on Adobe as well. Liquid text is not mandatory, it is for ease, but other linking documents are available. Undeniably, the cost of the Apple device is very tremendous, but there are other cheaper versions available. Online filing has made life ridiculously easy for litigants outside of Delhi. Now, this is the observation which we will have to ask. Outside of Delhi, are we only talking of Delhi or the entire country? Well, Justice Mushtaq has now started it in Sikkim. So, whether the litigants and the lawyers who are in the far flung districts do have the access to all these facilities. So, the life has become easy for litigants outside Delhi who would otherwise spend tons of money flying in and out to verify pleadings and then having physical notaries. Yes, that's true. That cost has indeed come down. One very interesting take is that photocopying, every time you went for photocopy, the cost was repeated. Scanning is one time. That's really interesting. So these are the few of the replies by the young lawyer. But now I would like to put my own viewpoint. When you are dealing with criminal matters in particular, whether e-filings would really serve the purpose. My experience, whatever little experience I've had working as a trial lawyer and then as a judge in this High Court and in the Supreme Court, that unless you are able to have a look at the original document in a criminal appeal, you would be really doing a great injustice. How do you meet this requirement in e-filing? That is perhaps what the new system will have to factor in. I'll share one single experience and then I'll close. We heard a matter wherein, in the Supreme Court, of course, wherein the accused had absconded. Proceedings under Section 299 were opened. And the argument of the lawyer before us was based on those scanned documents, scanned and translated documents. That, look here, sir, 299 CRPC was never complied. As a matter of fact, it was simply the 161 CRPC statements which were exhibited. The witness was never called in the dock to testify. I was little taken aback. It was a case from a Sessions Court in Delhi. So it really didn't go down well with me. I thought that it's not possible. District judges, the session judges, having had such great experience, would not really let this lacuna creep into the trial. So I called for the original record. It was, of course, just as we see the original records are totally torn papers, brown papers, taped. That all itself gives a feel of nostalgia. Finally, I got to that record. Every single statement had been recorded by the trial judge. It was taken under his own seal and signature. The witness had been summoned. His statement was recorded. Unfortunately, the same thing was not reflected in the translated copy of which the scanned version was presented to us. So, this is the small challenge, which is a very substantive one, in my opinion. I'm posing to all the IT experts to answer that when we need to fall back upon the original documents, which we should in original trial cases, how do we deal with that? So that is a small observation I would like to make, and of course the domain experts are here. They will probably consider my question and answer the same. Thank you.
Brother, as usual, Mr. Mehta has started that what's the real problem and how we are discussing of mandatory e-filing, how it can be successful. And in any case, we prepared this module, what is essentially required to be introduced therein. So mere filing is not sufficient. Wherefrom we are taking a record and we have to see those interfaces must also be equipped with this correct documents and thereby it should not be affected. I will put 4 points in which is essential probably at present. Then I will hand over to Govind Raju who will go for the discussion. 4 points is why we are discussing for mandatory e-filing module is number one, simplified, unified e-filing interface. Brother Mehta has pointed out that how the advocates and the lawyers can have acquaintance of everything until because they have to go for e-filing. I have discussed, I've seen from the Supreme Court. Supreme Court at present is dealing with two persons are sitting who were in the Supreme Court here. One is Justice Kalgaonkar and that Pushpa, who was from Madhya Pradesh C Committee. I know this thing. 2.0 model we are using. Now we proceeded to 3.0 model. Now in this, so many problems have been removed. And what the Supreme Court is doing at present, 70 AORs have been given on the basis of the pilot project and experiencing this. Am I right, Mr. Mishra? Anjani Mishra? Yes. We have given this to them. Then what are the problems in this e-filing modules? And which 4 things which we want to introduce in those things is number one, simplified, unified e-filing interface. Number two, system generated consistency means mandatory filing must system generated dockets, then indices, then pagination, then third, data interoperability and this digital silos, and fourth is infrastructure strength, how this can be beared with, and last is storage of every data. So these are 4 things which I am saying this is very essential for everything. And now I will hand over the mic to Mr. Govindraju who will go for the discussion. They are the domain experts and they have come from different high courts, all our 4 judges. I will say Dr. Anita Suman from Madras and Dr. Soumitra Dayal from Allahabad, Justice Mohammad Niaz CP from Kerala, and Govinda Raju, you know, from Karnataka. They have let them discuss how they develop their e-filing modules, how far it is workable, what are the problems, and how we can enhance it. So for that we are here. Thank you. I'm giving to Govind Raju, please.
Thank you, sir. All three of you have put the entire thing in perspective, different perspectives coming from three Supreme Court judges, which encapsulates everything. For the people in charge of the filing and decision making at the High Court, e-filing was spoken of as convenience for lawyers, as Justice Bhatti spoke of and Justice Mehta spoke of. Is there any interaction done with the lawyers to ascertain what they want? E-filing is also supposed to be a beneficial
Yes,
benefit.
it is required that you should little nearer to mic.
It is on, sir.
It is on.
E-filing, but the mic is not. E-filing is also supposed to be for the ordinary litigant to ordinary litigant who could file the case from his place using e-Seva Kendra or Gramavans. How does mandatory e-filing change that person's experience, and what are the things that your respective courts have done to cater to this requirement? Mr. Singh, would you like to start?
See, at present, I guess when we started, we have all looked at the lawyers first because they are the stakeholder who come to bring the litigation to court. And per se, in fact, coming before to this conference, we checked that we are roughly having 2,000 filings per day at Allahabad, but in person for the entire year, it's 366 in all. So of that, 50 or 60 have filed through E, only that much. So I would feel that we should look at the scale, which is because they're both stakeholders. Yes, the lawyers exist for the other stakeholder, but if the litigant is going to come through the lawyer, then I think there is no harm in looking at the lawyer first and then engaging with the litigant. My personal thoughts on that is also that if we look at the litigant first for filing, then we may be overlooking the aspect of legal advice being rendered to him before he comes to court, which is an important filter for courts. Our efficiency depends on the accuracy of the pleadings, their responses, and the arguments. So at present, we have looked at that, but yes, litigants, when they are the educated class, especially because we are dealing with writ petitions mostly and proceedings, intra-court appeals arising. In the criminal side, again, the litigant is already in jail, so he's not going to apply for bail on his own. He comes through either lawyer or through the legal aid in appeals as well. But yes, at present, that is how we are looking. There are difficulties which we are looking to solve because of I would again feel that we think paper and act E. So first we are requiring the document to be prepared partly because of our own compulsion that the annexures to the writ petition, they can't be Word documents always. So they have to be scanned. So you have a whole petition and then we scan it. So that paper involvement is unavoidable. And that is the catch-22 situation that we face. What to do then? The other is then when it goes to court, how you move with the kind of workload that individual judges have and the ease and convenience, because we are all products of the same society. We grew up writing letters to all our relatives, friends everywhere. Now writings have been replaced in the social space, many with the emails but formal work is still being done on paper. So if evidence is going to arise, it's likely it will be on paper. It's not easy to replicate at the present technological levels to say that, all right, this correspondence corresponds to this, the signature there's no way to verify unless you get the signature to the handwriting expert where the dispute arises. Yes, it doesn't arise in every case. Most documents get admitted, especially in writ petitions. But those are the kinds of challenges I guess we should look at. First, the stakeholder is the lawyer. We should look to resolve all his issues, interact with him more. First, we have devised a measure which has worked well, all right. They're not complaining, but yes, to make it better, we should engage with them, get their response, and then move on.
Just Sumant, any ideas on that?
Good afternoon to all of you. Thank you, Mushtaq, for this invitation for this wonderful conference. The first question that was posed was mandatory e-filing. I just want to emphasize and perhaps pause for a second on the word mandatory. And the reason why I do this is this. A few years ago, when we were trying in the initial phases of rolling out mandatory e-filing, we had an interaction with the bar. And the bar members looked at us and said, mandatory e-filing, how can you mandate it on us? You can't mandate it on us. So there are two schools of thoughts and perhaps two ways by which one would proceed. One is you take a tough stand and thrust it on them. You roll it out and you smoothen the processes along the way, and somewhere in due course of time, it happens. The second is you find out how best they can be eased into the system. And I think the Madras High Court has had experience in both. As far as the district is concerned, we have been very successful in rolling out e-filing. We're almost 100% there. And that is because we told our district judges, we want this done, we would like this done. We will give you support to the best extent possible in terms of providing the processes, obtaining the infrastructure and the resources from the state. When I say resources, human resources as well as other resources in terms of hardware, monetary resources, support systems, etc. But find your own ways of doing it. And the trick there perhaps is to give them an incentive in terms of this is a suggestion which we have made, which is still at the stage of the rules committee. But we want to include in their annual confidential report a column to say how many of them are tech savvy, how many of them have been able to implement e-filing in their courts. Once they know that this translates into something which is tangible, and the judges know that there is somebody is watching to see how successful you have been, that will make a difference. And so when we put this kind of a pressure, sorry, it's not a nice word, but persuade, thank you. The persuasiveness, quote unquote, on them, they rise to the occasion. What they did is some of the judges, this is the feedback that we get. They say, if your case is e-filed, we'll give you priority in the court. So they find ways to incentivize people to file. So as far as the districts go, we took this approach. As far as the High Court goes, we have not been very successful. Our e-filing is only about 10% mandatory. And there are difficulties in this. As Honorable Justice Mehta said, we insist that even though you e-file, you also give us a physical copy, which in fact defeats the entire purpose of it. Now, having said so, Madras High Court is poised well as far as e-filing is concerned. And I would like to share some statistics as on for the month of February 28 to 2026. Our total filings, both in the district court and in the High Court, were 1,64,037. And out of the total number, the number of cases e-filed in the High Court was 4,205, and in the district, 70,257, making it a total of 74,462 out of 1,64,037. So that's a good figure. And in fact, the last month before this, we were top of the line. In February, I'm given to understand we have slipped to the second position, so we must be doing something right. Our IT registrar, Mr. A.S. Ravi, is here, and I would like to just introduce him to the august gathering here. And I would also like to thank him for having supported us with these statistics and all the other material that I have on hand. So as far as the High Court is concerned, we are still evolving the methods by which we could increase the 10% to a more respectable figure. And one thing that I would suggest is response time. If there is an issue that crops up in the course of e-filing, and if the registry brings it to that particular judge and says, as far as your portfolio is concerned, there was this difficulty, response time is very important. How soon the judge is able to understand the issue escalate it. If the judge concerned is not tech savvy themselves, how soon they are able to understand, assimilate it, escalate it to the technical team or to the e-committee and find a resolution. That is key. That is for the first question.
Yes, Nias.
Good afternoon, everyone. As far as the Kerala High Court is concerned, from 2022 onwards, it is mandatory e-filing in the High Court
Yes.
and in the District Judiciary from 23 onwards. Therefore, there is no choice.
Yes.
Just
Brother Nias,
to speak some little.
just I want to assist you. When this word mandatory was used by us in Kerala, what type of resistance
We did face.
we have received, how it has been gradually phased out. If at all it suits you, you may preface it with that.
Correct.
Because when we said mandatory, people have gone that far to say that my client has a right to come to Kerala High Court.
100%.
Who are you to tell me whether I should come by auto or car?
Correct.
Since it is Kerala, they put this question to me.
Correct.
I said, no, we will not say anything. You can come to Kerala High Court, whichever way you like. How we have provided incentives to the lawyers and also the litigant public, please tell. Then, even if we use the word mandatory, how it has been gradually eased out.
Correct. In fact, we did face a lot of objections from various quarters. All the stakeholders were consulted. They were taken into confidence. Though it was in phase, I only said from 22 onwards in the High Court and 23 onwards in the District Judiciary, it has been mandatory. And it's a High Court where 40,000 writ petitions are filed every year. There has been no reduction because e-filing was introduced. True, there were bottlenecks, there were problems. Even now, even at this stage, we are having a monthly meeting of the e-committee with the Advocate Association, with the Advocate Clerk, everybody. And their suggestions are taken, the periodical improvements are made, and incrementally. And today, there is no problem as such because this is getting on well. But only because all the stakeholders could be taken into confidence. And we thought it was a transition. And therefore, there will be some teething problems, glitches. They were taken care of, remedied. And today, across all jurisdictions, all categories, in both the High Court and in the District Court, it is mandatory e-filing.
Without backup paper filing?
No, physical papers are being filed. About e-filing, it is mandatory. That's all I said.
To keep them busy.
And today, they will not be able to find out any other job other than doing the clerk's job. It's a social issue.
Anyway, as per the discussion you all have discussed, 2-3 things has come: trust, then ease to them, and third is incentivize. All thing. This is how we can brought into the picture all this mandatory e-filing, maybe a mode to make it easy, and the people must go on that. I have recently, we have to go in Madhya Pradesh High Court for inauguration on one software they have developed. What features they have developed therein, certain relevance as there, I'm putting of that because it may be useful for the purpose of preparation of the e-filing module. What they did is, suppose filing is there, here in Madhya Pradesh there is a change. What we take it when e-filing start, we have one sheet. In that sheet we fill up everything, and from that courts and everything we get every record from the trial court and everything. So automatic captures the district court appeal datas, everything. Second, automatic mapping of the subject matter of the roster listing. Even the cases would go for roster listing. That would be. Then automatic calculation of limitation period. This is a very normal. Then online defect notification. This is now the Supreme Court we have started. Then automatic fee calculation and payment. Unified access via bar, council and enrollment number. So they can get by that. And then their real-time case status update, and the free paperless registry operations started. And in this, they are connecting with the some police stations and everything. Suppose a bail application got listed, then the judges need not to have anything. You have a crime number, you push it, you can get it everything on your dashboard. So this is one of the features. If we develop like this, is one of the problem Brother Mehta has told, that the original scanning, the scanning which has been done, we don't know what is the scanning done. Now, if it's since beginning, if we start connecting of this, then there may be these are the issues. We can only say this much: when paper filing was started, e-filing module we have started in only in somewhere in 2004 we started e-code project. Now phase 3 is coming, we are on that. These problems would be there. How make it ease, that we have to work out. And so far as incentivize is concerned, when these processes is included, case is already automatically listed, they need not to go with anyone. It would be a ease for so many things. So we have to work out on this, but we have to go ahead to prepare how the e-filing module, which is universally acceptable, changing with the state wise some issues arising, that maybe can be done, and that may be done by the permission of the committee. And recently, Honorable the Chief Justice in the Chief Justice's conference has touched this issue, why we are preparing of the e-filing module universally. And Mustaq was also there. He spoke on that also. So all the Chief Justices are sitting here. They were aware of this. Now we have to proceed positive direction, positive thought, and we have to go ahead. Thank you.
One small observation on the lighter mode and yet very serious. We in India have the habit of using the James Bond style: shoot first, think later. All of us are moving towards this paperless system. There are challenges which every one of us who works on the screen faces. The challenges with the eyes. Yesterday, I was with one of the judges in the Delhi High Court. He was carrying the now classically used hyaluronic acid preservative free eye drops. Every one of us, times to come, is going to face huge problem with our eyes, dryness particularly. So, while we are developing this system, perhaps we need to migrate to some kind of hardware which would be easier on the eyes. If we start working on that right now, perhaps in times to come, our children, our successors will not curse us that yes, there are so many things. So we, while we are doing it side by side, we can think on that and also advise what can be the preventive measures. So same problem I'm facing, every one of us would be facing extreme dryness because of continuous watching the screens, not only this screen but this screen also. But the preventive measures have to be taken. That was in a lighter vein, but still very serious issue which must be addressed. Thank you.
Brother has pointed out pollution. You know, we are in Sikkim, so we preparing a model where there should not be no pollution, but pollution would be there even for everything. Whenever we go on interface, internet, anywhere, it's a pollution is there. That is bound to happen, but how we can minimize it? That is the crux. And manage.
Minimize the harm.
Minimize the harm and manage it. Two things.
Though there are several problems that we have spoken of, one of the basic problems which is being spoken of or complained of by lawyers and litigants is as regards internet connectivity. Not being able to file it at the last moment on the last day of limitation, and or it getting rejected because the server is not working or he does not have the internet. The document getting rejected because it's not in the proper format. Document getting rejected because the size is more than 5 MB or 10 MB, whichever the high courts have fixed. Is there any training program that is resorted to by your respective courts for the lawyers and the filers, including the clerks and the litigants, to cater to this so that they can file it in a proper manner and it gets accepted by the registry, number one. Number two, if there is a rejection on account of internet because of limitation, is there any fallback mechanism that has been implemented which will accept the file even though filed 1 day later to be within limitation, so that the litigant doesn't suffer? Any actions on these by your respective courts? Yes.
In fact, this is taken care of. In- Whenever there is a server downtime or a portal unavailability or a connectivity outage, our e-filing rules will exclude that type. And if it is restored, you can file it. It will be treated as a deemed valid institution so that the litigant is not in any way prejudiced for no fault of his. Because if we want the litigants or the lawyers or any stakeholder to believe in our system and they are acting on it, they can't be found fault when there is a trouble from our end. So this is taken care of under the e-filing rules in the Kerala High Court, which is framed by the Chief Justice under Article 229. And this is taken care of so that there is no litigant who will suffer because of this.
Yes, Sumant?
The filing is done through the e-Seva Kendras. We have about 315 e-Seva Kendras. We have people on hand to ensure that whatever are the difficulties that are there are quickly and efficiently gotten over. If they happen from private homes or offices, then if there is anything that is escalated to the level of the section, then yes, there are people in the section that can help them. In the district court complexes also, we have a team of uh, assistants who will be able to assist them for any issues that arise.
There's a help desk kind of a
Yes.
system set
We've
up.
got kiosks.
Yours.
Kiosks.
Multi-level, you can say, very simple help, providing for help at multiple levels. One is through audio video measures that are available, direct training to a limited extent. We have a very big bar and an even bigger number of clerks that who are there. A helpline mechanism is obviously in place, and not a single incident has been reported where any petition may have got rejected because it was time barred. Because we have a time stamping mechanism in place, so even a failed attempt gets time stamped. And once it is presented, once the stamp is available that it has been presented on such and such date, that's it. Period of limitation is taken care of. During COVID, everything was relaxed as everywhere, but barring that, not a single incident.
That's interesting. The very first time it's presented, the fact that it's presented gets date and time stamped. So irrespective of any faults, it's cured next. That could be one
And
of the ways.
even we have allowed,
Even if it is done later. Yes.
and so far as the file is concerned, it's stepwise filing, so he can save at every stage.
One other aspect which is spoken of is as regards how quickly is it registered and listed once it is e-filed. Of course, we spoke of incentives that if it is e-filed, it is listed the next day. But there, one of the issues that has come up is whether it is completely automatic listing or is it manual process of listing even after electronic filing. Have you, in all these three courts, implemented automatic listing? And if so, how have you done it so that we could share the best practices here? This is the thing.
So far as we are concerned, till the stage of when it says e-file, so the stamp report is what we call it. Once that is done, and that is also there's a program built, so it works on that. Once the report is clear, then there's nothing in the hands of any individual. It's all machine run. It will go up to filing and to the court. The issues that arise are up to filing, up to the defect removal, curing of defect. That is an issue. It's some issues have many things have been resolved, but yes, everybody needs an improvement. That needs an improvement because there is a once you bring in a paper, the clerks were very used to it. No lawyer, mostly the petitions are not finally stitched up and placed before for reporting by lawyers. So that was always in the hands of the clerks. And some mistakes are clerk centric. So that is, I believe, where we have to improve and provide to ensure that a If it is a defect-free report, it will go in fast, and that is how we can, one of the ways we can incentivize e-filing. While saying that yes, it is mandatory, moving towards that, not diluting that goal, but to incentivize would be easier because then once the matter reaches court early, there's nothing better for a lawyer or the client or the clerk or anybody. But yes, there are elements who don't want it to go very quickly.
Could self-assessment be done at the time of filing, or could a tool of uh, machine defect finding, could that tool be made available
Yes.
publicly
Yes,
so
we are
that at the
exploring
time of
that.
filing they run through the process?
Very true. Very true. We are exploring that if we can provide a test report. You scan it, sitting in your office, you scan it, take a test report. Yes, of the lawyer.
It
We are
comes on
working.
the dashboard of the advocate who is filing, then he has to rectify those defects, and accordingly we can proceed further.
Yes, that will be very valuable, and that will in fact solve the problem. Incentivize it to the point that then it's a defect-free report petition always.
Yes, Sumant, in address.
Yes. So once it is filed, an e-filing number is generated, very akin to what Allahabad has. They have an e-filing number too, and that is at the stage prior to defects, which is done manually. The passing is done manually at the stage of which they look for defects. If anything is to be amended, corrected, that is done. That usually happens within 24 hours, and then an SR number, and then a number is given, serial register number, and then a number is given. At that stage, technically, the matter is ripe to be listed. Now, where it takes time is a scanning. That's where it takes time. So, normally, if I were to file a matter today, it would be ready to be listed tomorrow. But if it is a matter involving voluminous compilations, case law compilations, documents, etc., that is where it takes time. So if it is a matter where there is some urgency, then the counsel would make a mention before the court and ask for an out of turn listing slip. And the court normally obliges, if they are able to establish urgency, you issue the slip, which means that it gets put on a fast track. The matter gets put on a fast track, they scan it, complete it, and then bring it. So that's how the processes are. But our processes are quasi, they are not
completely
hybrid
automatic.
They are not
You still have
completely.
the hybrid model which you
We have a hybrid model, and we have our passing officers who go through every paper.
In fact, I would just like to add, besides the e-filing, what we have done is started for the last 3 years is even physically filed files, fresh files. Those are scanned at the stage of filing, and they will all go available to the judges. That is perhaps being followed everywhere.
Just
Even
for the information of everybody, Allahabad has a scanning of nearly 30 lakh pages a day. It is something which is humongous. Probably if 30 lakh pages we do in Karnataka, we'll finish the entire digitization in 2 or 3 months. That is the scale that Allahabad is at. Of course, it is the largest high court, but kudos to the entire team. Yes, yes.
In Kerala, if it is a defect-free filing, a number is assigned automatically and it is listed. And if it is a bail application and a writ appeal, it is machine scrutiny. There is no human element involved at all. The machine scrutiny, it is numbered and sent up the very next day.
This we did touch upon. Once there's a digital filing, is it required that it is printed and placed before the judge? Or would the judge be dealing with the e-file document with a dashboard on with the judge? Is the same digital record also available to the lawyer, or does the lawyer carry the physical file into court? Are they all on the same page? Because it's not only the initial filing that I'm speaking of, it is subsequent filing, which we in Karnataka we have come up with a word called add-on. You file case laws, you file memos, you file applications, all those things. Again, how do they go about the digitization? And are they available on the dashboard of both the judge and the lawyer, so that the paperless is not only for the judge, paperless could also be for the lawyer not carrying paper into the court? Is this journey going ahead? How far has it gone? Indexing also, sir.
Indexing till final hearing.
Till final hearings. Because the case is not one stage. It comes before us for so many times. Normally, when we say it is final hearing, is what we take it up. But during the process of the case journey, there's so many things which keep on happening. How does that cater to? And does the lawyer have to carry the file, or does he have everything? The other most important thing was about the digital evidence and electronic documents. Large volumes, call detail records, financial statements, they're all uh, presented without proper indexing. Is there a search capability which is there? Is any software being used so that there could be a questioning made of those documents to do a proper summarization? Are you using AI for the purpose of digital evidence and electronic documentation and during the course of final hearing? This is near.
Yes, we have in fact our in-house team has developed an AI chatbot, which will help us in summarizing the documents and also in handling the large volume like call data record running to pages or a 300-page contract. You can get it summarized. You can get detailed events. All this is done. This will substantially reduce the time.
This
See, as far as AI is concerned, our team has developed a couple of softwares. We have not been able to integrate it as yet because they are pending approvals at various stages. One is called an integrated bail management system, which has various facets of bail hearings and how it would go from filing of the bail application right up to the time the bail order is issued. We want to integrate it with the jails and the police stations. Now, in fact, we have developed that module which is pending before the Honorable Supreme Court E-Committee for its approval. The second module that has been developed by us is for an
Software. We also, Ratan also has done it. And MP has also done it.
Recently, what has happened, I will apprise for that. One matter from Uttar Pradesh came before us, wherein we found, with an order of the division bench of the Uttar Pradesh High Court, that if a person whose application for premature release of probation is pending since more than 6 months, they be released automatically. Mischief played was that in those cases, a person who is of 2 year, 2.5 year, 3 year, 4 year, they applied for, and their applications period has spent 6 months. Finally, in terms of the direction of the division bench, so many prisoners have been left without completing even the minimum max period prescribed for that. So this matter came to the attention of the Court of Supreme Court. In the meantime, the full bench of the Allahabad High Court passed a judgment. No, this cannot be done, and this judgment of the division bench is incorrect. But even then, what happened? The people who have been released that have not been brought back to the jail, either they absconded or they have not been brought back to the jail. So now in that situation, we called some NIC and everyone. Then we have developed for those purpose, particularly for premature release, a software ought to be developed wherein if a person, as per in terms of the policy, every state do have a different policies. So in terms of those policies, a state by module must be prepared, and that must be connected with the e-prison module. How many prisoners are there? They completed that period, data is available. Then it should be processed from the office of the deputy jailer and it's reached to the stage of, so complete mechanism automatic provided, and it would start 6 months prior. So UP completed, Madhya Pradesh I called, so Madhya Pradesh completed. So now probably it will be done. This is one of the automation in that field.
I think we are running out of time. One last question is what I'm told. One of the reason the rule book gets thrown at us for any of the initiatives which are taken. The rules do not provide for this. The rules do not provide for it. If you do this, it will be contrary to the rule. Are there any amendments that you have made to the rules or proposing to make to the rules so that they can be made E and E friendly? And these all the things that we have spoken of now could be catered to with the rules helping them rather than hindering them. Just a thing.
That's a constant process being undertaken, mostly largely because of the initiatives of the committee, Supreme Court. So wherever measures have been adopted, yes, rules have been amended. But it's like building a bridge when you cross a river. So once we reach that, as we are developing, it will remain a constantly evolving state. Because the even what we the infrastructure that we have today, certainly it's not going to survive another 10 years. So again, the rule will require change. So that is really not bothering us because wherever we reach, the rules haven't hindered us anywhere. Wherever we have wanted to do, we have amended and provided.
Now we can put some good suggestions if all judges are here from various high court. They can give good suggestions or good practices that can be taken note of. And if uh, kindly give, please, kindly give mic there. The judges want to say something.
There,
Organizers, please
Anybody,
provide the mics
please
to the lordship.
raise some hand, please call.
the mics are on the table.
Yes, sir.
Am I
please.
audible, sir?
Yes, you are
I'm,
audible.
I'm Mantha from Calcutta High
More
Court.
than audible, sir.
Sir. uh, two issues I just want to, in fact, all three of your lordships from the Supreme Court have pointed out the need for a physical copy along with a mandatory e-filing. It should be considered a temporary phase to ensure on a long-term basis that the physical filing will gradually be phased out. So that is one part of it. The second part of it is in the context of a criminal appeal hearing last week that we were conducting at the Jalpaiguri Circuit Bench of the Calcutta High Court. The charge was under 376 of the IPC, of the former IPC. The medical report that was shown to placed before the trial court, or the trial court said this document has gone in unobjected. Whereas we found the medical examiner of the victim was not brought on as a witness to prove that medical evidence. And we later found when we examined the trial court records that there was an objection recorded in red ink. So the trial judge missed it out. We found it, and of course, there was other corroborative evidence for that medical report that was different. Now we had to look at the actual trial court records. So my first suggestion would be that along all trial court original records should be scanned and be made available. This will avoid delays in bringing the trial court records, which we find in many cases, even cases filed in 2012, sir. Some trial court records have not come into the High Court. This is one part of it, sir. Along with the
Brother, we have understand.
Sir.
Brother, we have understand.
And one more problem, sir. Just one more: translations. Translations are a serious issue in the trial courts. The English language is not something we clearly understand. We don't know what to say. We say something else.
Brother,
Something else is understood.
may I
Sir.
suggest you one thing? At present, we have to discuss certainly a roadmap for mandatory e-filing.
Sir.
These are the practical problems when we are hearing the cases. We are not saying these problems are not genuine. These problems are genuine, but we have to thought that at this stage, when we are going for mandatory e-filing, what may be an essential required for which, and can we fulfill those here at the stage of e-filing? Therefore, this problem may not arise. So your problem has been, I think, taken note of. Justice
Just
Anjali
one
Mishra
more
is sitting.
addition, sir.
So that
Small
can be
addition.
put in.
Small addition, sir. Along with the Sir, small addition along with
Yes, sir.
the
Yes, sir.
original scanned copy of the record. The translation and the original must also find place in the High Court records.
Sir, we are facing
We are
this
only-
problem every day in a Supreme Court every time. So
This is
sometimes we
this is
call the
only-
original record.
Only a
So
suggestion.
this
to the-
problem we are saying this mandatory e-filing we are discussing now. Prior to that, e-filing was there. So now mandatory. So once we go from e-filing to mandatory, and prior to that, filing was there on papers. So we have to thought 100 year. Now we have to eliminate this.
It's a gradual process.
Only thing is what we are discussing for mandatory e-filing at this stage, what niceties we should include, thereby this module can be betterly served to general public, advocate, and everyone. So this is our thought process, sir.
One small suggestion, sir.
One suggestion, madam.
One small suggestion, if Lordship permit. Lordship, the submission is that in Rajasthan, we have done it in little bit phased manner. Like 22, we said central government advocates should do. 23, we said all state government should do. 23, and we said that all division benches should do. Division bench filing should be filing. So if it happens in a phased manner, in addition to what the learned Dias has said, in addition to that, if you do it in a phased manner, then it will be easy to persuade the lawyers. Thank you.
Yes.
My lord, advocates are opposing, my lord.
We have already, I pointed out in
Number
four
one, my lord.
issues,
Number two, my lord, we are giving
infrastructural is strength,
number two, my
meaning
lord.
thereby capable of 40 Gbps throughput. Until this is there, we are already set. We are having this issue, but
ma'am.
this is infrastructure. We
Another
are
mal-
preparing a roadmap for e-filing.
Yes, another, my lord. Another, my lord, we are giving free scanning to the councils, my lord. Free scanning through e-Seva Kendra, my lord, we are giving to the councils, my lord. Previously, we are giving e-filing also, we have done, my lord. Now e-filing has been gradually stopped, my lord.
One, the basic thing is, if judges are ready to do it with paper, then gradually this will come into place.
All right. Yes, Mr.
Can I share two experiences, sir? First is of Supreme Court of India. When this e-filing started in Supreme Court, there was resentment among the members of the bar and also the lawyer clerks because it related to their employment. So the Supreme Court started to educate the lawyer clerks first. 450 lawyer clerks were educated how to e-file that. They were given good lunch. They were very happy. then, then thereafter, sir, the Supreme Court provided them a space along with the computers to sit there and upload their e-filing. First, and other incentives, sir. The other incentive was it was mandatory to file 3 copies of every petition, which was reduced to 1 copy. Then thereafter, the Supreme Court took the burden of that printing that 1 copy also. When the printing charges were 1 rupees 50 pice per page, which was reduced to 75 per page, 75 paisa per page. So gradually,
You told me at that time when
yeah.
I was.
And one more thing I wish to bring to your notice, sir. We are talking about e-filing. What we are doing, sir, they are typing the petition on their computers, taking a printout. They are bringing the printout to the registry. Registry is scanning that, and thereafter the e-filing process. So we are not moving toward digitalization, as Justice Mushtaq had said. We are simply moving towards digitization.
Digitization.
Paper is scanned and we are saying that we have started e-filing. This is not e-filing, sir. E-filing should be
You are right.
digitalized e-filing.
You're right.
That's it. Thank you.
May I tell you one experience?
Can I
Instead
just,
of it,
can I
yes.
just add one line? In fact, we should have a kind of forms. Like for SLP, what is the form? For appeals, what is the form? They should type straight away on the form. Maybe XML or some, we have many kind of forms. And then they could be taken into the system and automatic scrutiny, etc. That is e-filing. This is scanning and all this business.
That I am saying that Madhya Pradesh, it is started long back. He is also
Yes,
aware of
and
this
one
thing.
one more, we could sensitize those lawyer clerks. In fact, it's not taking their livelihood. They may be channelized to some other kind of work. Somebody has to look after those systems as well. Thank you.
May I tell you one experience? When COVID came in 2019-20, I was the Chief Justice of the Andhra Pradesh at that time. The peoples were suffering. Filing were not possible. The staff was scarcity. I was 1,000 in place of 1,000. I was having 300 only. Then at that time, the Andhra is technologically very sound. I called some persons, and within 2 days, 3 days, they prepare the module for e-filing. At that time, our judges, and the Andhra judges, I gave the access to them, Zoom meetings, how you have to file. So the situation arrest filing started. So two things. One is thrusting as came, not going on thrusting. Thrusting must be as contended by brother judge that if judges start working, it will come. It would not be a thrusting with condition, it automatic. One thing. Second thing, ease, make it ease them. And third is incentivize. So these are the implementation processes. First, we have to go by mandatory e-filing module. So we have to discuss mandatory e-filing module. What is essentially ingredients we should brought in, thereby this may be successful for digitization. Thank you.
But in Bihar, we have started 100% e-filing in all the district courts from today. For this, yes. For this, we were preparing for last 2 months. What we did, we organized camps and we encouraged the lawyers to get themselves registered on the portal. So we kept on motivating them. During 2 months, we got grand success in persuading the lawyers in getting themselves registered. So the decks were cleared, and from today we made it 100% mandatory. In High Court, there is already 100% mandatory, and in High Court, two courts presently, the Honorable Chief Justice and myself, two courts, division benches, we are doing paperless courts. So we are on way
Thank you.
doing this.
Thank you. Can we
Sir,
close it?
we have to just submit one thing about the mandatory part. We in Gujarat High Court, we are coming out with our own e-filing software and paperless software. So before going with that, we called meetings with all the stakeholders, the lawyers, the advocate clerks, government officers, and I'm very happy to say that all of the stakeholders are now on board with us. It is mandatory, but voluntarily mandatory.
Thank you. Thank you. What?
So we have one last discussion.
Yes. He is the expert man.
So, Worship, I will share my views. Honorable Chair, Honorable Co-Chairs, distinguished dignitaries on the dais and off the dais, and respected participants, a very good afternoon to all. After enriching myself with insightful views shared by Honorable Chair and the distinguished panel, I will keep my part very short. We observe that the nature of our discussion has changed. We are no longer reviewing how e-filing will be rolled out. We are now reviewing the present by asking how well does it work? And more importantly, how can we make it better? At present, we are in the transition phase. We have the system, we have the software, and we have the intent. But effective implementation of e-filing still require careful alignment with ground realities. As Chair pointed out, that one of the most practical concern is that even today after e-filing, physical copies are required to be submitted before the registry for listing of matter in many high courts. A lawyer who is one of the most important stakeholder in the justice dispensation system has concern. If a physical file has to be prepared, why go through the additional effort of electronic filing? Why is not in, what is it in me for it? Similarly, there are issues related to the submission of the original documents in certain e-filed cases. At the stage of exhibiting the evidences, original copies are required to be produced before the court. Therefore, our rules must be clearly addressed and when and how such documents are to be submitted. We also need to examine whether in civil cases we can dispense with the requirement despite the CPC mandating the physical production of the document. This brings me to the point that technology alone cannot bring the reform. In the Indian judiciary, the real reform lies in our processes. I would like to suggest a few suggestions for promoting, which was, it's a reiteration of the facts only. Identification of certain categories of cases where e-filing can be made mandatory, especially on the matters where the government is a party. Honorable Chair pointed out that incentivizing advocates whose case is filed through e-filing. Early listing can be another option. Creating awareness for e-filing through e-Seva Kendra to the advocates as well as litigants. Developing the user-friendly interfaces that is very simple and easy to operate. So I will just point out the vision which e-committee is envisioning. The vision of the e-committee under the leadership of the Honorable Justice Vikram Nath and Honorable Justice Anjani Kumar Mishra is to focus on judicial process re-engineering so that the existing rules, acts and workflow can be revisited and aligned with the technological advancement. Rules are blueprint of the software development. Moreover, the vision is to move toward automation, where it is related to the extraction of the metadata from the PDFs, automatic communication of the defect at the time of the filing, and reducing human intervention in registry processes like scrutiny and listing to promote efficiency. Before I conclude, I would like to thank Honorable Justice A. Mustaq, Chief Justice of Sikkim, for organizing this conference and bringing us all together for this meaningful discussion. Conferences like this are important because they all allow us only to share our successes, but also to openly discuss the challenges we have faced in the implementation. It's a wonderful opportunity to understand the underlying issues and to work toward a future-ready judiciary. Thank you.
Thank you. While closing, I will say that nothing is more powerful than an idea. Nothing is more powerful than an idea, and this time has now come. Thank you very much.
Thank you, Lordships in the dais and distinguished guests, for this thought-provoking and insightful session. We will now have a 15-minute tea break. The organizers are requested to escort all the distinguished guests for the tea break. Learned Senior Advocate Jorge Namka sir to kindly present the traditional Sikkimese Khada to the distinguished panel comprising of Honorable Mr. Justice Atul Sridharan, Judge, High Court of Judicature at Allahabad. Honorable Mr. Justice Ravindra Maithani, Judge, Uttarakhand High Court. Honorable Mr. Justice and Sanjeev S. Kalgaonkar, Judge, High Court of Madhya Pradesh. I now request the learned senior advocate Tashir Abdin Barfungpa sir to kindly present the traditional khada to the moderator, Honorable Mr. Justice Anjani Mishra, former judge and vice chairman, E Committee, Supreme Court of India, to open. I kindly request the distinguished moderator for this session, Honorable Mr. Justice Anjani Mishra, former judge and vice chairman, E Committee, Supreme Court of India, to kindly open this session.
Good afternoon, everyone. I hope I am audible. We'll begin by the opening remarks by the chair, Justice Bishnoi.
A very good afternoon to all. Brother Justice Arun Mansali, Brother Justice Atul Sridharan, Brother Justice Mathani, Brother Justice Sanjeev, Brother Justice Anjani sir. Today, we are here to attend this 2 days conference on technology and judicial education. The theme of this session, rule process alignment and re-engineering, captures the most critical challenge we face in our leap towards the digital judiciary. We often talk about technology, the apps, the portals, the AI, but I would want to point out before that technology is merely a tool. The real reform, as the session rightly indicates, lies in re-engineering the foundational processes of the existing judicial system, aligning them with the rule of law and establishing an institutional vision. It is to be borne in mind that digitalization is not the mere replication of an offline process on a screen. In its true sense, digitalization ought to and should mean true re-engineering. That is to say, doing away with the outdated rules and the practices. Re-engineering the process means to enhance the judicial productivity, both qualitatively and quantitatively, to make the justice delivery system affordable, accessible, cost-effective, transparent, and accountable, This is the mission, and at heart of this re-engineering lies the e-filing. Now, the stepping stone towards the process alignment and re-engineering are that mandatory electronic filing, e-filing, and it is not merely about scanning paper documents and uploading them. It is about re-engineering and fundamental processes of the court administration. The core reform lies in linking e-filing to the back-end automation. All statutory judicial registers, daily cause lists, filing registers, motion lists, final order, judgment register should be automatically generated from the structured metadata captured at the time of filing. In other words, when a party files a petition, the system extracts data fields, the party names, case type, relief sought, lawyer details, etc., and immediately populates the register. This eliminates manual register writing, reduce human error and duplication, and prevent inconsistent cause title indexing. By removing these manual steps, the registry can shift from being a data entry center to a quality control and case management hub. This is process re-engineering in action. We see the principle being vigorously applied across the country. For example, the Rajasthan High Court, on the instructions of the Supreme Court, has made e-filing of all division benches cases mandatory, with civil cases following suit, pushing for a compulsory paperless High Court. The Bombay High Court has mandated e-filing for a host of matters: commercial division, direct and indirect cases, and non-commercial arbitration cases, even introducing an online Google form for urgent listing to reduce paper inflow. The Delhi High Court has given a slew of directions to strengthen the e-filing across the district courts, including mandating it all for all civil jurisdiction and criminal complaint cases, which is very essence of aligning rules with the digital process. Even the Punjab and Haryana High Court now mandates e-filing for specific cases, categories like civil writ petitions. This is not a scattered effort. It is a national re-engineering movement. Now we come to the court management and case management from the registry to the bench. We have to understand that e-filing is not the end, it is the base camp. The track to the summit is a paperless judiciary. After implementation comes next the great challenge, which is case management. If our processes are truly aligned, e-filing should not just change how we file, but how we manage. Once data is uploaded, automation technologies and AI can be deployed to process matter. We are already seeing this in Supreme Court, as the Supreme Court, in collaboration with the IIT, has developed and deployed AI and machine learning tools integrated with the electronic filing software and identification of procedural defects in petitions. These tools are enable metadata extraction, party names, case category, relief, and can also be integrated with the integrated case management and information system. Once integrated, we could create a system which would reform the entire system and registry level duplication, and registry level duplication can be avoided. This system would work as follows. Once a defect is identified, the system notifies the filer with a time window to cure it, exactly the registry level duplication that the core reform seeks to avoid. Furthermore, this technology can help in intelligent listing. E-Code Phase 3, 2023 onwards, puts in place intelligent smart system enabling database decision making for the judges and registries with the scheduling on prioritizing cases. A specific goal is automating the registry role in listing of cases to bring transparency and reduce manual intervention. Some of the examples of our High Court, a pan-India re-engineering. This re-engineering is not a distinct dream, it is present reality, albeit the teething issues. The Sikkim High Court is on the course of become a fully digitalized and paperless High Court, a beacon for others. The Madras High Court has mandated strict adherence to e-filing for criminal cases, and while it had to put a district court mandate on hold due to some teething problems, but I think so now it has been informed that they are going to implement it soon. It showed a commitment to streamlining the process through the coordinated efforts with the police and judicial staff to rectify lapses. This highlights a critical aspect. Process re-engineering must go hand in hand with the addressing stakeholder concern. To conclude, the use of ICT system is not just about efficiency, it is about reinforcing the rule of law. Every file uploaded on an electronic system captures its metadata, timestamp, user detail, edits made, creating a transparent and tamper-proof record. The e-service summons is a game changer. The e-committee has launched NSTEP, a centralized process service tracking apps enabling bailiffs to serve notices electronically, track their GPS location, and capture proof in real time, drastically reducing delays. As we move forward, complete paperless system, we are duty bound to ensure this re-engineering is inclusive. Our vision must be to ensure just for all, beyond all physical boundaries and disabilities. We must equip our legal services authorities with the necessary manpower and resources. The establishment of e-filing help desk counters in court complexes and the Nyay Kaushal e-resources center are steps in the right direction. Technology, after all, is a means to higher goal. Our re-engineering process must be guided by the core values of access and inclusion, ensuring that the benefit of a transparent, efficient, and speedy justice system reach the last person in the queue. Now, what we are discussing about the challenges, but these challenges will come once the e-filing is made compulsory in all the courts. We hope that soon it may be the dream come true. And I've been, when I was discussing with brother Arun Bansali, then he was telling me that Supreme Court is also thinking on this line. And they asked from some officers about to prepare this type of system, that how to minimize this paper in the this registers and how to do all this paperless. And I think so the brother Anjani ji will throw light on that. This now, this is what we are we could face these challenges when the paperless paperless court and this will come to the ground. Now I'll request brother Mansali to throw light on it some.
Honorable Justice Vishnoi, Brother Justice Atul Sridharan, Justice Ravindra Mehtani, Justice Kalgaonkar, Brother Justice Anjani Mishra, Chief Justices, Computer Committee chairpersons, and distinguished experts and fellow participants. It is indeed a privilege to be a part of this landmark national conclave on technology conference. A conclave of this nature for reviewing the past, re-engineering the present, and redefining the future could not be more timely. As we gather here today, we stand at a pivotal moment in the journey of India's justice delivery system. Over the last 2 decades, the Indian judiciary has made remarkable strides through the e-court project. We have introduced e-filing, virtual hearings, digitized records, and online case portals. Millions of citizens can now track their cases from anywhere. These were necessary and important first steps, the phase of digitalization. But digitalization alone is not enough. Simply scanning papers or replicating manual processes on a computer often replicates old inefficiencies at digital speed. True transformation demands something deeper, process reengineering. Process reengineering means fundamentally rethinking and redesigning our workflows, not just automating what exists, but questioning why it exists and how it can be made radically better. It requires rule alignment, ensuring that our procedural rules, statutes, and institutional practices are fully synchronized with the capabilities of modern technology. As was question was put by Brother Suraj Govindraj, that when the e-filing is made, then objections are raised by the office that it is not provided in the rules. So the rule alignment is that you have to make rules which are friendly with the e-filing. This is a shift we must make from digitalizing the registry to re-engineering the registry itself. At the heart of this re-engineering lies one of the most impactful reforms, mandatory e-filing designed to replace physical institution registers. Imagine a room filled from floor to ceiling with dusty leather-bound registers. That was the physical memory of our institutions for centuries. I'm reminded of a personal incident way back in one of the matters where there was a overwriting in the physical file regarding the date of institution. So my senior told me that go to the record room and find out from the register as to when this matter was actually filed. So I went there. The officer who is posted there is normally on a punishment posting. So he told me that those registers are lying somewhere. You go and search and find out. So it took me 1.5 hours. And when I came out of the record room, I was filled with dust and DDT powder, because DDT powder is kept in the record rooms for ensuring that there are no insects there. So that was the position. At that point of time, it continues to be so because, yes, it continues to be so, but just to replace it from something better, or rather by a click of a button sitting in the office itself, we would know that when the matter was filed. Today, when a case is filed, the registry still manually creates and maintains multiple physical registers. Lawyers or litigants submit documents, registry staff scrutinizes them, and enter data in again, index causes, titles, and update various statutory registers. This multi-layered manual process is time consuming, error prone, and resource incentive. The new vision is clear and powerful. When a litigant or advocate files a case through the e-filing portal, structured metadata captured at the very moment of filing should automatically generate all statutory registers. No separate manual entry, no duplication. The system itself becomes the single source of truth. This reform is not merely technological, it is profoundly institutional. It requires us to align our rules of practice, civil and criminal procedure rules, and the High Court registry's guidelines with digital realities. We must amend or issue new rules that recognize electronically generated registers at the primary
and authoritative records. By capturing structured, standardized metadata at the point of e-filing, party details, nature of case, statutes invoked, relief sought, annexures, and more, we can auto-populate everything downstream: registration, scrutiny reports, defect memos, cost lists, and statistical reports. This single change helps us eliminate five major demons of the current system. First, manual register writing. Hours spent by registry staff filling bulky registers can be completely eliminated, freeing human capital for higher value work and ensuring 100% accuracy. Two, registry level duplication. The same information will no longer be entered multiple times across different systems. Enter once, use everywhere. Third, post scrutiny data entry. No more re entering data after defects are cured. Scrutiny results will be tagged directly to the metadata. Fourth, inconsistent cost title indexing. Variations like AB and company versus state. Now you will find that somebody will say AB and company CO dot. Somebody will say COMPANY. Versus the state, somebody will write a state, somebody will write state of UP, somebody will write state of Uttar Pradesh. So there will be all different. Being indexed in five different ways will end. Structured metadata will ensure a single searchable standard. Fifth, inefficient and unintelligent listing. The advantage of this reform is intelligent, automated, causeless generation based on real-time metadata, case type, urgency, parties, etc., free from human bias and delay. Rule alignment and process reengineering must be guided by a bold institutional vision, user-centric design, processes built around the need of litigants, advocates, judges, and registry staff. Data as an asset, accurate real-time metadata, turning our systems into powerful tools for analytics, dependency reduction, and policy making. Standardization with flexibility, uniform national standards for metadata while allowing high courts reasonable accommodation for local needs. Integration and interoperability, seamless connection between e-filing, case management, payment gateways, and future AI tools. Capacity building, continuous training so technology becomes an enabler, not a barrier. This transformation will not be without challenges: resistance to change, data security, and privacy concerns, bridging the digital divide and ensuring robust infrastructure for disaster recovery. These are soluble if we approach them with collaboration, institutional will, and continuous stakeholder consultation. When we succeed, we will achieve faster case registration and listing, reduce pendency through elimination of avoidable procedural delays, greater transparency and tamper-proof records, lower costs for litigants and the system, better utilization of judicial time, enhanced public trust in the justice delivery system. Several high courts have already taken pioneering steps. We must now scale these successfully nationally through aligned rules and re-engineering processes. As Justice Vishnoi just said, we were discussing, and I have information that e-committee at the national level is now getting into this re-engineering and rule alignment thing. So let us hope that we get a something which can be implemented across the nation. In conclusion, moving from mere digitalization to genuine process engineering through rule alignment is the next frontier in transforming the Indian judiciary. Let this conclave not just be a platform for discussion, but a catalyst for decisive action. Let us commit today to reviewing and amending procedural rules that hinder digital efficiency, prioritizing the capture of structured metadata in e-filing systems, making auto-generated statutory registers the new normal, building an institutional vision that places technology at the service of justice. As we re-engineer our processes, we are
not just modernizing a system. We are reaffirming our commitment to the constitutional promise of justice, social, economic, and political for every citizen. The future of Indian judiciary is digital, efficient, transparent, and public centric. Together, through thoughtful rule alignment and courageous process reengineering, we can build the future. We have a very enlightened panel. We look forward to your valuable insights and deliberations in this session. Thank you.
Thank you, Justice Bishnoi and Justice Bhansali. Basically, what emerges is that the discussion needs to focus on what areas require process reengineering. And especially when we talk of process reengineering, to my mind, there are two aspects to be considered. One, for making the process user friendly, and secondly, to ensure that it is aligned with the legal requirements. Now, I'll give you an example. Under the CPC, when a suit is filed, there are certain provisions which provide that certain documents which are the basis of the claim must necessarily be filed along with the plaintiff. Now, how do we deal with this when we are moving towards mandatory e-filing? This is one aspect which requires consideration and discussion. The other thing, of course, is of manual registers being maintained. That should not be a difficult process, but I would like to have the views of the panelists as to what their high courts have done in this regard. Justice Sridharan.
So thank you very much, Justice Mishra. And Justice Bishnoi started off and gave a very large and a great overview as far as the subject is concerned. And he also mentioned how this technology is to be used as a tool and it's not an end to itself. And that the digitalization is meant to, as a means to re-engineering judicial productivity. And then he also mentioned about mandatory e-filing, which was already considered and discussed in great detail in session 1. And then linking of back-end automation to the to be generated automatically. As far as this is concerned, sir, you had also mentioned about a pan-India re-engineering of the filing process itself and the pitfalls that can come in the way. In fact, just coincidentally, I was discussing with brother Sanjeev Shukla during over a cup of coffee. He had mentioned that why do we have so many different nomenclatures? Where different courts have different nomenclatures for their cases. And in fact, even one high court which may have a particular nomenclature that is sought to be changed when the Chief Justice changes. He feels it should be a slightly more easier one. So, Justice Mishra, with your permission, can I just bring in Justice Shukla over onto this, the conversation that we had?
Yes.
What was your views on having the common nomenclature, sir, if you could just mention it?
Just to fill you up, this exercise has already been undertaken by the committee once in 2017, and probably it was shelved. What they did was that different nomenclatures were mapped to one another in the software, but the nomenclatures of the various high courts were allowed to exist as they were.
Anyway, we were discussing on this issue, saying that whenever the Chief Justice changes, if he comes from south, he brings the nomenclature from south. If he comes from north east, he comes with that nomenclature. So each time we have to go for new nomenclature. Why can't we have pan India same nomenclature? If say let us patent appeal or intra court appeal, it should be intra court appeal everywhere. But that would make it further easier for detecting the data on a national grid also. That how many LPAs across India are pending. But if there are different nomenclatures for different high courts, then it's very difficult to discern that intra-court appeals, how many intra-court appeals are pending, pan-India, how many criminal appeals are pending.
So that's a practical difficulty, what you're saying in a pan-India re-engineering,
that's right.
if it doesn't have a common nomenclature.
And second suggestion was that, like we are discussing here, that we have to realign the rules with the changing technology. Why can't we have a model rules prepared by E-Committee of the Supreme Court and replicated by all of us with some small modifications, if at all required at the regional level? But we have all the high courts have different rules. We could understand the high court rules may be different, but so far as this E-regime is concerned, we can have a one set of rules
which is uniformly applicable and is replicated everywhere, and model rules can be prepared by the E-Committee of the Supreme Court.
Precisely for this purpose, we are in the process of setting up an office consisting of 5 judicial officers to look into these aspects and to frame model rules. So that process is underway.
Right.
And Justice Bansali Saab, you said that one of the main aspects that you pointed out was no separate manual registers to be maintained. Now, that would be the crux of process reengineering. The very purpose of that would be to reduce the duplication of data. And if we can, I was just thinking whether it does exist or not, whether you can have a system where even if a physical copy is presented in the registry, from the point of scanning onwards, creating the index, marking the page numbers, and right down to the storing of the data in the servers to be utilized by the judges, the lawyers who are all linked to the same system, sir. And but there comes in the problem because as far as data integrity is concerned, once the data has gone into the servers, how do you ensure that the data integrity is maintained? So as far as my technical knowledge, sir, is limited. So, sir, with your permission, can I just get it, Justice Suraj Govindraj, on this on blockchain? On blockchain, we how see once the data is scanned and it goes into the servers, how do you continue to ensure that the data integrity is preserved and that there is no subsequent change to what has been scanned?
So there's a popular misconception that blockchain cannot be hacked. It is not that a blockchain cannot be hacked, even a blockchain can be hacked. The blockchain works on a multi-ledger platform where the same data is stored in different places, and the uh, presumption or the assumption is that even if a person were to hack one place, he will not be able to hack all places simultaneously. So if the data is in 10 places, even if by some quirk of fate and by some providence, if somebody were to hack into 3 places the data will change, but 7 places the data will not change. And there being a date and timestamp, those 7 places where the data is not changed is taken as to be the valid and verified data.
And it will also, but the advantages of the blockchain would at least identify that the document has been tampered with.
Exactly. Now,
That much it will
once
give.
it is hacked into these 1, 2, 3 places, there'll always be there's a hash value comparison which keeps on happening between all 10. And when the hash value comparison happens, it shows throws up a trigger. It shows up throws up a warning saying that there is somebody who has tried to hack it, and this particular data has changed. So that is known to all the 10 places. And that time, these 3 can be put back to the other 7 original, so you'll always continue to be having the original, the proper one, verified data.
So, and Mr. Saab, what you had picked up was, especially in suits when they are filed in the trial courts, that's a major problem because the original document has to be filed along with it. Only that can be exhibited. But at the stage of the High Court, with regard to writs, I mean, the original documents are not required, the photocopies are sufficient enough. So, wouldn't that at least be workable in the High Courts?
It could be. That is how these rules, e-filing rules, have been structured in the Allahabad High Court and the various high courts. But just a thought, especially in testamentary jurisdiction, the will is always required to be filed. Once probated, it is kept in the registry. So probably we can have some sort of a registry where these documents which are mandatorily required to be filed are kept, so that the courts can at least take a look at the original and not rely mainly or exclusively upon photocopies.
So, sir, I give it back to you, sir. You can. Next question.
Another this about the maintaining registers and all. This is also part of the rules that
Yes,
the
it is.
courts has to maintain so and so register. Then we have to mandatorily amend those rules also for that purpose.
Yes, rules have to be amended. That's why I said that process reengineering also necessarily entails relevant modifications, amendments in the rules and the law.
Then you have to when you are thinking over it. So what's the idea about it, that you will provide rules, universal rules for all the courts in India, or
That
what?
is the idea at the moment.
At the moment, yes.
But again, the problem is that we we can only suggest. as the E-committee, we don't have any uh,
that power
power to direct any high court.
that is
Ultimately, it is the high court which has to.
so once we are thinking of it, yes, then certainly all the courts or all the high courts will follow it. What's the problem in
No, that is not a problem. But that is just one issue. Sometimes the high court feels that something is being pushed onto them unnecessarily. That is also
that we can take care of this.
Justice Mathani, would you have to add something?
Honorable judges, on and off dais. Thank you, Sikkim High Court, for being paperless, showing the path, and making all of us feel proud that we are part of a system due to amalgamate with the National E-Governance Plan now. Before I come to this process re-engineering, I would like quickly go in the past. Before this CIS or E-Court we started, earlier also attempts were made to computerize. So the word that time used was computerize the courts. In UP, that was District Court Information System, which was initially phased out. It did not work. As Justice Misra has rightly said, the E-Committee is not creation of any statute. It's administrative orders. Just the then Chief Justice Lahoti just wanted that to assist me, there should be a committee. That is how it come into existence. We must not forget that process re-engineering has to be done. We cannot afford not to do it. Just a few days back, when I got information for this conference, I was in a court. I asked that why you are not giving slips for any document that is filed in the court and registered in the CIS. They said the rules have not been changed. We don't have that rules. The provision is in CIS, but the clerk is not giving it because rules doesn't permit it. Here is process re-engineering. And as an e-courts, let us think of it. As an e-court, we have not innovated something as a judiciary on our own. It's a national e-governance plans component is this, which was launched in the year 2006. And e-court is one of it. Today we know that if we need to get our passport, it's a paperless. ITR, paperless. Banking, paperless, most of it. And multiple departments, pension, land records, paperless. We are not pioneering it. We have to integrate with it. Otherwise, we would be lacking behind. And 2007, when first action plan was launched, I wish we would have read, if not heard, read the speech given by the then President of India, Mr. Kalam. He envisages what we are envisaging today. A total paperless scenario. He would talk of a national ID and going to the portal, looking for the lawyers, making pleadings, information to the opponents, and all those documents. If it is a land document, from land record grids, verification. If it is a bank records, bank grids, confirmation. And similarly, when the defendants puts the cases, then hear virtually and decide the cases. That speech is basically something to be read. Now, what will happen of the registers? Entry once made in the grid anywhere in the Indian judiciary, that should not be re-entered. We should be able to capture it, navigate it. We should have horizontal and vertical integration. I had a lot of privilege to be associated with these projects. I know this Madhya Pradesh High Court, they had integrated the courts vertically also. I did not define it in a greater detail. But when we talk of, right now the topic is rule alignment. Rule is for what? To my understanding, we need to first visualize what we want to go, what we want to do, how our system should work. And this is integral part with the ITting and the judicial setup. For my high court, if I want to go for e-filing, somebody files a petition and not in the PDF form or scanning, no. Some forms, which are in many forms, just filled, data capture, scrutiny, notification to the adverse side. In the meanwhile, since even today in the criminal courts, we get some data from CCTN. We get some data from e-prison, e-forensic, that's available. Interoperable judicial system, at least in Uttarakhand, it's operational now. Any step we have changed our rules. E-summons, we have changed our rules. Our summons police officers is not giving that for the report now. It's a vertically on the GPS based. So once we have a plan to do it, we may do those things in pieces, but our rules should be made once we reach that place. These are the rules now. So that should be the process. As far as the registers are concerned, in UP and Uttarakhand, I have seen perhaps this general rules service, there are hundreds of registers and 80% of them are obsolete. Why do we need those hundreds and thousands of entry? Today, with a click of mouse with many combinations, we could get the data. What data we need? Even if from NJDG, we could get those data from each court. So registers may be done away, but yes, who will do it? That's very important. And time has come for all of us, personally, I feel, that sit down and work on it. What should be the rule alignment? How the system should work? And it's not doable. It has been done here where we are sitting today. So anyone can do it. So how we want our code to work? And then all those rules definitely would be obsolete. 20 paisa. For example, in Uttarakhand, we wanted to have e-true copy rules. So when we were discussing, they said, who will pay the paisa code fee? I said, do away with the fees. Give it free of cost. All right, it's a rule. We have created 2 ana per page earlier. 2 ana. So no paisa. We are not taking any paisa. We have e-code rules, and within 30 seconds, one could get a e-true copy. Anyone can get it. And believe me, lawyers have given representation now that the copy should be given to lawyers only. And it was full court agenda. Yes. What should be done? We rejected. We have gone far ahead. Why should come back? So my take is that rule engineering, this we have multiple questions. For example, then we have to validate. For example, service, sufficiency of service. If the services somebody has on the structured form filled a writ petition, say, and notice goes through mail or whatever mode he has in WhatsApp number, everything. We know that we get the receipt through mail also, e-post or whatever that. So that should be given validation. Multiple verification, maybe in the Bharatiya Saksha Adhiniyam now and Bharatiya Nagrik Sanghita. What is that? So we in very tough to remember the word. So we need amendments and authorization and certification at that level also. Means the change should be at that level also. Once we go 100% that ecosystem. So that's my take, and registers may, and yes, we cannot afford to say no. Rules are to be aligned. We have to work it, whatever manner we do it. Otherwise, we will be. We take pride that in COVID period we have done tremendous tasks. We have done it. Of course, we have done through VC video conferencing. It was an ad hoc kind of things. But when we talk of paperless and ecosystem, now we should have the rules. How to push the information. How much access should be given to other cases? Support land record, they want from us. So these and many such things may be perhaps require deliberation. Thank you very much. Thank you, Chief Justice Mustafa, for giving this opportunity. Thank you so much.
Thank you, Justice Methani. I'm told that Madhya Pradesh High Court has done very good integration right to the grassroots level. So therefore, probably Justice Sanjeev Gaukar may enlighten us on that.
Honorable Chair, Honorable Justice Vijay Bishnoi, Honorable Chief Justice Arun Bansali, Honorable Vice Chairman of E Committee, my senior, my guides, Justice Sridharan, Justice Methani, and Mr. J. Honorable judges here. I'll start with a statutory warning, sir. I have worked for 20 years in the ground level, for 7 years at the higher level, and for 5 years at the highest level. So I have bag full of experience and 3 bag full of advices. So please restrain me if I go tangent or cross my limits. I'll start with the rule. Why rules are required? So now Bharatiya Nagrik Suraksha Sanhita and Bharatiya Saksha Adhiniyam 2023, they came into force. Section 54, 94, 105, 180, 185, 202, 209, 230, 231, 251, 245, 262, 265, 266, 308, 310, 316, 335, 356, 392, and the last provision, but very important provision, 530, recognizes electronic evidence. Then Bharatiya Sakshi Adhiniyam, section 57, 61, 62, 63. And certain electronic processes are made mandatory. It would be mandatory to record the search and seizures. It would be mandatory to record the video of crime scene. It would be mandatory to record the statement of vulnerable witnesses. Rules are there. Provisions are there, but rules are not there to recognize this. Where to keep this electronic evidence? Where to keep? On pen drive? On DVD? In 2016-15, we made the rules recognizing the use of DVDs. Now, do your laptop computers have the DVD players? And one scratch on the DVD, entire digital evidence goes. One magnetic field, and your digital evidence is gone, which is preserved on a DVD or a pen drive, thumb drive. So where to keep this? So the central government come up with an idea of e-Saksh portal. There will be a central repository wherein all the police evidence, whatever police has collected for search and seizure and crime scene recording, they will be kept on a platform, and we will provide you the access. Now question comes, who will maintain, who will archive that? Who will have access control to that? What about the preservation of? Who will be responsible for preservation of those electronic evidence? What should be the time limit for preservation? Our appeals get decided in 15 and 20 years. So we need to preserve that electronic evidence for 20 years at least. Then how to exhibit those electronic evidence in evidence? What will happen to admissibility of those electronic evidence? These are very pertinent questions. We may need to make rules on that. So we need to make rules for reception, storage, retrieval, access management, preservation of the electronic evidence. Rules are required, sir. Second, sir, where to keep? These are e-Saksh platform provides only for two things: the AV recording of search and seizure and AV recording of crime scene. What about the other digital evidence which are coming to court day in and day out? The CCTV footages. Every criminal case there is a CCTV footage filed either by the prosecution or by the defense. Call details. There are multiple, sir. WhatsApp chats, communication through other social media. Where to keep all these digital evidences secure in our custody, in the custody of the court? Have you ever thought of planning a digital malkhana in the court? We don't have, sir. We have physical malkhana where the physical files are stacked, but we don't have digital malkhana. We don't have capacity to keep those digital evidence secure for years together. Tamper-proof boxes. We don't have. So we need to think on these directions also. Then Rajasthan High Court has done wonderfully well for this e-summoning. They have prepared the rule first, then lodged their Twarit. Madhya Pradesh has also done that. Why it was required, sir? Recognizing the service through electronic mode. The Bharatiya Nagrik Suraksha Sanhita merely says that the summons can be served through electronic mode, but it does not provide for recognition of that service through electronic mode. So we need to create rules for that. There should be rule regime. Then video conferencing rules. First came in 2018. Then thereafter, there had been many changes in VC platforms. Again, sir, when a witness deposes through a video conferencing, how would you show him the copy of will and ask him, where did you sign this will? exhibition of that will, how will you prove? Are you going to send the physical copy? Ask him to wait there at Calcutta. I am sending from Madhya Pradesh, and thereafter we will commence your evidence. No, sir. We need to provide a rule regime for these kind of challenges also. Then, sir, from where he is deposing? From the luxury of his home, sitting in front of the WhatsApp screen, and the person is holding gun on his head. We need to recognize the access point, remote access point. We are replicating the court atmosphere through a medium of distant connectivity. So we need to ensure that the atmosphere of court is created through this medium also. We need to have the rules for that, sir. Then Honorable Judge was discussing about pan-India rules, sir. At least uniformity in the nomenclature. So that is not feasible. My humble opinion is that that is not feasible because the high courts are independent in themselves. They make their own rules. No one can guide high court to create rules as per convenience of the statistical information. When this national judicial data grid started, sir, this challenge came to fore because every high court had a different kind of nomenclature. Then an exercise was undertaken to map whatever nomenclature you have in your jurisdiction with the nomenclature in other jurisdiction. Those were maps, and a common national this thing statistics was created and ported on national judicial data grid. The ideology behind that was when we indulge into trade with China, we don't ask them to recognize rupee for trade, or we don't recognize their currency for trade with us. We don't ask them to learn Hindi or English first. They don't ask us to learn Mandarin first. We create a bridge between us and we communicate. So that's way we can communicate with other high courts. We can create a bridge software that if high court is saying that it is a miscellaneous petition, we will understand that it is miscellaneous petition in their jurisdiction, but it is miscellaneous application in our jurisdiction. So these kind of things we can work out, but we need to have the rule. I'll restrict myself on this rule. I'll again, if you permit, I'll speak on that process alignment and re-engineering later.
Yeah,
Thank you.
please do.
Brother Sanjeev, you stated everybody here with this. Yes, is right in that way. You have to this make the rules for this purpose. What he has this electronic evidence, how to prove, how to do all these things. So I think so. This is the area where we have to ponder. And this e-committee, yes, certainly e-committee is not having any mandate to force the high courts to do that, but some way has to. We have to find some way.
No, we can advise. It is up to the high courts to actually accept or not accept or accept with modifications they consider appropriate. On the panel is also Mr. Jay Thoreja, is CPC Delhi. Maybe we can hear him also what he has to say on this.
Thank you, sir, for this
Personal
opportunity.
experience.
My remit here, I guess, is to be extremely brief. So, first of all, I would like to thank. Don't think I have the benefit of having Justice Mohammad Mushtaq in the room, but I'd like to thank him for giving me this opportunity of being on such a platform. It's a rare thing for a judge of my station to be here, and given that we are running short of time, so I just have very few points to make. Some things which are relevant from my vantage point. The first is that if a high court truly has to achieve process reengineering, there has to be some synergy between the rules committee and the IT committee. And one way I would suggest of achieving that is there should be identity of members. At least 2 or 3 members in both the committees should be the same. That results in very quick transmission of ideas and plans. The other suggestion or idea I have is that the registrar rules of the High Court should ideally be someone who's previously been CPC. I'm not pitching a case for my elevation to that position, but or somebody who has been a master trainer of the E committee, because that again makes this process of alignment very easy between those two committees. The next thing which I have to say, I agree with Justice Bishnoi. Process realignment, re-engineering, the precondition is e-filing or digitization at your level. Apart from that, I genuinely believe that every high court needs a data center. That is the center point at which you are supposed to house everything. And if today Madhya Pradesh is succeeding as it is succeeding, it's because of that excellent data center that they have. So that is a precondition. That is where every data of the high court of the district court should be brought in. And then we have to see how the processes can be aligned around that data. And the last input that I have to give is that a lot of process re-engineering is coming from the legislature. As sir has rightly pointed out, e-Saksha. But we are now even looking at MedLeaper and e-forensics, where the legislature and the executive now want us that the MLC should also be stored with them. And as a judge doing a trial, I should only get a hyperlink through which I go to that particular portal and access that MLC. So the question is, do we want traditionally the document has been housed with us? Once the MLC comes on my file and it is with my Ahmad or my court custodian, I maintain the sanctity. If it continues with them, then yes, you can probably involve blockchain technology. But what it only guarantees, as I've learned now, that if there is a change, I'll get to know there's a change. But the original document is most likely lost. So we, while doing our criminal trials and this criminal jurisprudence, really need to think that whether these e-sakshas, these videos made by as per section 105 of BNSS, the MLCs, the postmortem reports, and the forensic reports are to be housed with us, maybe as a copy, or are to be still housed with the state, which is a litigant before me and fully capable of, as I have learned reliably in my tenure as a CBI judge as well, fully capable of tampering with them. So this is my input on the subject.
Now, what happens if there is electronic evidence and you store a copy, as you said? Does it not become secondary evidence?
I concur, sir. And I would genuinely believe that a lot of process reengineering would, apart from requiring change in rules, will require change in statute.
Then what having your own data centers, there's been a push towards cloud storage also.
Yes,
But
sir.
personally, I may think of data storage on site with us. But then there's been a great push for cloud storage
I
also.
know, sir. As a CPC, I have encountered documents of the government of India insisting that we should go towards cloud storage. But I absolutely concur with you. I have always been susceptible about keeping things with the executive on the other side. I want control with myself, and that's the view which my chairperson at the Delhi High Court also shares.
The cloud is being pushed by NIC, definitely, not by the government. Uh, we are also looking at the cloud model that has been, which the committee has been paying for the past several years. And I realized that the cloud service is not being offered. What we have been paying for is the hardware, the number of servers. A cloud service is never hardware, it is a service. So that is also something we are taking a relook at. Any questions from the audience?
Sir, I have a question. I am Anup Chitkara from Punjab Haryana High Court. In e-Saksha, when the evidence is uploaded, how do we supply the copy to the accused?
Actually,
Because even if the rules have to be framed, question is it is not downloaded.
no, it is not being downloaded. This is one aspect which we are working on. Almost about 40 meetings have been held between the team which is uh, designing the software and the committee. So this aspect has not been resolved.
What would be the consequences of the trials which have been held without supplying them the e-Saksha documents? It will be a fatal defect.
Yes.
I'm Saurabh Banerjee from Delhi High Court. Now, there's another issue with respect to what Mr. Tareja was saying. The supplying of the MLC uploaded in the cloud or whatever it is, the moment it is sent for the trial commences and the evidence whatever the witness or whoever it is, the prosecution, they ask for the document. The moment it is open, the number of times it is opened, the logarithms change, and then it is no more a primary evidence.
Actually, this is one of the instructions that I have already issued, that the hash value should not change. And even if it is being displayed, while it is being displayed, you also display the hash value which should match with the hash value of the original.
So with respect, I'm just saying that. So in my little knowledge, I'm not even connected or anything. In my little knowledge, sir, when a document is created, the original hash value has to remain. And if the banking is on the e-document in the MLC or any form, then please appreciate, sir, we need to, the trial court needs to go through that day in, day out if the course of 13 witnesses or 14 witnesses are there. There is a probability of minimum 20 to 25 changes. So what I'm just suggesting, I don't know what, the hashtag remains, the original hashtag remains. The number of additions, alterations, whatever it is only supposed to be recorded in the order sheets. Then there is no change in the document per se. The primary evidence still is the primary evidence of the original hashtag. I don't know, sir. This is my suggestion. This is what.
So the hash, when it's generated on any document electronic, the original hash is recorded. The original hash is recorded. The change happens if it is saved or transferred to another medium. When that change happens, there's a different hash value. What could be generated is a chain where the changed hash value is also recorded on the chain, like blockchain, what we spoke of, that this is hash value 1. It became 1.1 because of this particular thing, but it's always traceable to 1. So the Angama on hash value, which is the defense counsel makes out, he wants to make it out because he wants to throw a doubt into the mind of the judge or mind of the appellate court. But the hash value, if we go back, the hash value of the original always remains the same. It's only the change which needs to be recorded, and that process, if it is taken care of, everything falls in place.
So just one more thing. Accessing the document will not change the hash value.
Accessing per
And
se will not.
just having a look at it and then closing it again, it's not going to change the hash value. So usually in criminal trials or civil ones also, the documents they are seen by the court. And the question arises when an exhibit is marked on it. Whether the hash value would change
Changes.
when you mark it.
Again,
So if we make annotation on a document on the electronic reader, annotation we say change. If it is a layer on it to make classify it as so, but when it gets saved, it's a new document.
Yeah.
It's a new hash value. So if we have the original document stored without any change, and the documents which are accessed with annotations or otherwise, that is immaterial because we can always go back to the original filing
Correct.
to verify that hash value. Unfortunately, during the time of argument before this is where some training is required for the district judges and the magistrates, that don't get enamored by this change in hash value. Go back and refer to the first hash value. This hash value has changed. It is bound to happen. And there's no harm in it happening. But just refer to the first hash value to find out what is the actual hash value and compare it. Don't go by the argument or the defense because that is what they are paid to do and that's what they will do.
What?
Yes, there's a train. There's a trail which there's an audit trail which can be established. Yes.
No, sir. What with Justice Sridharan? Sorry.
I'll answer to
So what
I'll answer to your query. See, electronic evidence is preserved by hash value in eSaksh portal.
Yes.
Yes. Thereafter they came to me. We had a discussion. We said all the subsequent changes should be kept in a package file, which is attached to the original document. So, like the date of its creation, the time of its creation, all these facts are kept in a package file attached to the original document.
So that's
Even when you mark the exhibit on the document, when the document is referred to and admitted in evidence, that exhibit marking or any material object marking will again go to that package file without disturbing the authenticity of the original document. So that has already been taken care. It is done.
I agree. So the original document remains as
Same,
it is.
same.
What is being used is a secondary part. Whatever, how many times it is opened, how many times the marking is done, it all reverts back to the original document as such.
It will not revert back. It will be saved in a
Hashtag.
package file attached to the original document.
The hashtag will remain same.
Yes,
because
yes.
it's there.
Hashtag of
That's
original
exactly.
file shall remain same. Another query you raised that about that Medley-Par report, that medical reporting. Madhya Pradesh is facing another peculiar position on that. All the revenue records have been digitized in Madhya Pradesh. And now they have stopped giving the certified copies, saying that whatever we have already put it on the website. You access, you put in your survey number and access the document. Is that a certified copy of the electronic record?
Sir, I was sitting in a division.
Unfortunately, it's no.
I was
So
sitting.
that is a big challenge. We are framing the rules to recognize those documents which are kept on the server of concerned revenue department. Again, rule regime is required.
So there is
Whenever our rules are passed, we will be happily sharing with you.
Right.
Any other suggestion or something, koi query?
Problem, just a problem we may face with regard to uniform marking of application suits or whatever. In some high courts, the writ petitions are filed before a division bench. In some high courts like Calcutta, writ petitions are filed before single benches. Then the question comes when whether an LPA would lie or not, whether it comes under 227 or 226. That is one issue. There is another issue. For example, criminal revision matters are filed before single benches in Calcutta High Court. Whereas in many high courts, 226, 227 and CRP and 482 are filed in one petition. Bombay. So the nomenclature, to bring a uniform nomenclature, will be a real challenge, sir. Earlier, the exercise was mapping it.
Sir.
And if I remember correctly, the biggest opposition was from we received was that the larger high courts, citing that they have a history of 100 years or 150 years. They are not ready to change their nomenclatures. So that was it. But still, it could be.
It can be done,
Yes,
but
yes,
then there has
for,
to be
for last
uniform.
3 decades, it could not be done. The work has been taken up by the Chief Justice Conference, probably in the late 90s also. And 2017, what has been done, it has yet not been implemented. So the issue really is a debatable issue.
So with the permission, just last thing on process reengineering, I
please.
reserved this for the finale, the cherry on the cake, sir. Process reengineering, sir, it requires mindset reengineering first, not the process reengineering. Process reengineering will follow. I'll just make an incident, sir. Police authorities, when we started this e-summon, police authorities came up with a wonderful objection that, sir, we need to purchase first the tablet computers to serve the summons, and again we need to train them. So it will take time. Don't implement it. So I asked him whether your constable these days have the smartphones or not. Bole, sir, they have, but they don't use it. So I asked them, these days, if a person is having a smartphone and don't know how to use it, he must be a sadhu, still using Nokia 2010, or a shaitan who is watching YouTube, messaging on WhatsApp, but he don't want to do this official work on his. So instead of giving them tablets, give them an app which is inbuilt in your in their mobile phones. Pay them for internet charges 300 per month. They will happily accept it, and they have done it.
Sir, I'll just say
Thank you,
one
sir.
thing.
It's mindset reengineering. That's it.
Just with permission of Justice Vishnu, one thing. In my court, the cases come regarding e-Sakshya, battery debt.
These are the so these are the some challenges which we have discussed thoroughly here, and some certain points. Just as Brother Mathani, Brother Sridharan, and particularly Brother Sanjeev, they have raised very pertinent points, and we have to find answers to these queries. If we want to achieve this e-filing and all these paperless courts, then these are the challenges which you have to met. Rules have to be amended. Very pertinent point that electronic data where to save and up to what time, how many years you have to save. You have to find an answer for that also. And for that purpose, you have to take together the government also for that very purpose, and to make understand the high courts also that yes, these are the necessary changes, though you are independent on your own, but please do these things for the purpose of achieving a goal for that, sir.
Just to add one item, sir. Today, the cost of implementation of AI, which we are speaking of, to get one GPU is going to be difficult for each high court. We need to have a shared infrastructure for the purpose of GPUs. GPU we can order today, even if you have the money, it won't come because there's a full queue which is available. It's only at the Supreme Court level that probably the GPUs could be secured because Supreme Court will get, the E committee can get the GPUs. If we have 5, 10 GPUs, that could be shared among all the high courts and that resources would be available.
We are working on.
Yes, the 5 GPUs are coming now. So that could be shared.
One more thing, sir, just wanted to add is with regard to security, I mean, part of process re-engineering, especially what happened in the Delhi High Court. They had a robust system apparently, but there was a digital backdoor through which the hacker got in. He priced himself through and did something mischievous. But he stopped only as far as the screen is concerned. He could have gone further and had access to the servers and created mayhem there. Is it time that we start thinking in terms of a cyber security officer, which is a slightly more better term for a ethical hacker, who would consistently test the validity of our systems to find out how robust they are before the person with malicious intent actually sees it?
Absolutely.
CDOT has certain tools for monitoring. One tool will monitor externally. There is another tool which does an internal audit as well. So that is something that can be
In
used.
fact, a couple of years, sorry, please, a couple of years back in Madhya Pradesh High Court, the front page of the High Court got defaced. A casino's poster was put up there. Anyway, but as a metaphor, that must have had some kind of a meaning that whether you go to a casino or to the court, it's a matter of chance.
So you raised the issue about Delhi High Court. It's not something which is peculiar to Delhi High Court. We also suffered the same in Karnataka. There were 2 other courts also which suffered the same, where Russian hackers, then it was only jumping around, nobody knew from where it was coming. We have started using a software which Kerala started, vConsole, which is user authenticated. So that is something that we'll have to do multi-level video conferencing rather than point to point, which are these Zoom, WebEx. They are not made for courts. They are made for a commercial meeting. So we need to come up with our software for this. vConsole is one which I would recommend for all of you to have a look at.
No, we can also, perhaps the time has come to have a kind of expert team like Government of India has certain kind of certain the organization. So my experience is twice the Supreme Court website was hacked. So we had to approach those authorities, those people. They are very senior experts or different from different fields. But it took a lot of time even to take them on board. So this is in Supreme Court. What happens in Uttarakhand High Court? Something like this happens. So we can have a kind of certain kind of organization within judiciary, which could be maybe under E committee or something. Some
Actually, even
recovery kind of team.
even certain is being advised and is banking upon these tools which I said have been developed by CDOT. They are
In fact, one interesting fact has been given to me by Justice Kalgankar. The question is who manages the cloud services of NIC? This is in support of what Jay said. Meghraj is the cloud service. So in support of what Jay said that we should have our own first servers. Can anybody guess who is managing the NIC's Meghraj service?
Geo.
Sir, can I say something from Madhya Pradesh High Court? Uh, Basically, we have to store the data where? Our data center or the cloud. We have to manage things internally or externally. So we have to think about 2 things, sir. the E-Committee Supreme Court of India have given the SOP 1.0, where three options are given. Either you create your private cloud in your data center, either you
It
take
is
the
precisely what we are looking into. We are doing a rethink.
yes, sir. Or you take
You'll
the
get an answer very soon.
or you take
So
the
one more aspect, sir. I'm Aman Chaudhary from Punjab Haryana High Court. NIC is looking at e-Sakshar. So I don't know if we need some other player to look at it. The
Actually,
integration is not
it
happening.
is a team of NIC Madras which is doing the software in conjunction with the Home Ministry.
Yes, because I had taken up this point and they were very prompt on saying that we've been able to manage, but I don't think it's working. Defense councils are already
I mean,
taking
they are still working
advantage.
on CCTNS
And
2,
okay.
which was supposed to be launched on the end of February. That February end has not yet arrived. Let's see when it arrives.
And one more aspect regarding the witnesses appearing from abroad. They are also unable to, because the time difference is so much that they're unable to go to the consulate. So a lot of petitions are now being filed. So some rules have to be also brought in place for that aspect, that how they would be able to record their evidence if somebody is ailing and old and cannot come to the country, still wants, he's a complainant or an injured witness, and his examination is imperative. So how would that be? Because there are
That's what we are
judgments coming.
discussing that
I
it's
passed
not
one judgment on that, but of course rules are better.
actually, that's right. We have this is what we are discussing, that what type of challenges we are going to face and how to find a way. So it's a very brainstorming session, and I I hope that we uh, we are going from here with some suggestion, but lot of more questions also. So we have to find the way, and and the Sandeep is reason for that. The Sanjeev is reason for that. It's anyway. So I've been told that we are getting late because the dinner time is also there. So we'll take our leave. Thank you very much.
Thank you.
Thank you, Lordships in the dais and distinguished guests for this engaging session. Honorable Lordships and our distinguished dignitaries, with this, we conclude today's session. We extend our sincerest gratitude for your presence and invaluable contributions to this conclave. The technical sessions will continue tomorrow as per schedule, and we look forward to your gracious presence. Thank you and wish you a pleasant evening.